mechanism set up in S21 for interrogating prisoners, and he personally interrogated detainees himself. As numerous interrogators will testify in this courtroom, interrogators from S21, the accused verbally or in writing ordered the use of torture in interrogations, and on several occasions instructed interrogators on how torture was to be used. The accused admitted that he personally interrogated a small number of high-value targets, and the documentation and witnesses have confirmed such participation. The accused admitted, sometimes after being confronted with the evidence, that he did indeed participate in the interrogations, but he has denied inflicting torture other than perhaps on occasion a few slaps. However, the witnesses say that the accused kicked prisoners, he beat them with rattan canes, and applied electricity to their bodies until they lost consciousness. Former S21 cadre, witness KW16, will testify to witnessing a typical event where the accused disapproved of an interrogator's performance and beat the interrogator as a result. This interrogator was subsequently arrested and executed at S21. This was a typical example. Finally, witnesses will testify that it is the accused, through his annotations on the prisoner lists, who decided who was to be smashed. With these authorizations, the guards gathered the condemned prisoners, packed them into lorries, checked their identification before they were sent to their deaths in Chung Aik. That said, perhaps all the witnesses are in error, or perhaps they are lying, and in fact the accused was just a leader. You will be the judges of that. However, as we have seen, the accused's notes have survived and will surely be of use to you in passing judgment. Here, for example, you will see a report setting out that the accused was consulted during the grenade explosion incident. Here is another one. I beg your pardon, says Mr. Petit. This is Mr. Bunnarak's confession. The accused wrote a long analysis of the confession, at the end of which he proposed arresting Cham Sam-un. In points 2 and 3 of his conclusions, he also recommends investigating 3 other people and asks if Security Office 15 can search for and identify more people who might be connected to Cham Sam-un. Here is the confession of Sun, which Duch annotated on or about the 1st of September 1975, when he was still deputy chairman of S21. Duch has acknowledged that he wrote "not yet confessed" to be tortured on this confession. This document attests that the accused suggested to Ankar that 150 people should be smashed, and Ankar agreed. The accused admits writing, "suggest interrogation of 4 persons and kill the rest" on this document. And on this one, the accused admits writing, "Uncle Peng, kill them all." And lastly, here is the confession of Kim Sok on 21st of December 1978, which means it is the latest document to have come from S21 in the case file. In it, the accused writes a note discussing an individual called Trung, and he says, "Please allow me to arrest him." 15 days before the regime fell, here you see the accused eagerly asking for another victim. In all honesty, it must be said that the accused did offer sometimes detailed explanations for these annotations. For example, he claims that when he writes Uncle Peng killed them all, in fact he just wants to give Peng the opportunity to boast of his power to a subordinate. For others, as we have said, the accused claims that all he did was write down the decisions of others. It will of course be for you to weigh the explanations offered in light of the evidence in the record of the case. We are convinced that once you will have reviewed the evidence as a whole, including the testimony of witnesses, the admissions of the accused, the circumstances of the operations of S-21, and the documents, you will conclude that the accused was knowingly and intentionally in control of the entire S-21 criminal apparatus, that he had the power to arrest, to detain, to interrogate, to torture, and kill, and that he indeed used that right or authority throughout his chairmanship of S-21. Should you be convinced beyond a reasonable doubt of those facts we have outlined, you will then have to establish what type of legal liability those facts support. As the reading of the closing order has indicated, the former director of S-21 is charged with committing or with being responsible for the crimes committed at S-21 under multiple forms of individual criminal responsibility, that is, committing, ordering, instigating, planning, aiding and abetting, and failing to prevent or punish the crimes committed in S-21. The closing order concluded that those modes of liability were supported because the evidence showed that the accused had the power to obtain any criminal result he desired. It showed an accused who contributed significantly at almost every level of S-21's criminal machinery. And yet, we strongly believe that these forms of liability only account for a part of the accused's criminal responsibility and only uncover a portion of the S-21 criminal operation. As we have outlined from the very beginning of this process, we urge this court to consider and apply Joint Criminal Enterprise, or JCE, to the facts of this case. It is not appropriate at this stage to delve into the details of this submission, but suffice it to say that in all its categories, more particularly in its first and second ones, JCE applies squarely to the facts of this case and would allow a full accounting of the accused's responsibility. Specifically, if you were to find that he had acted as co-perpetrator with his subordinates in committing criminal acts to achieve an agreed upon result, then he would have to be found as having committed those crimes just as if he had committed them directly himself. If, on the other hand, you were to conclude that by his acts he significantly contributed to the commission of the crimes of his co-perpetrators, then he would not merely be an aider and abettor, but he would have to be found guilty of committing crimes and sentenced as having committed them. That, I submit, is why JCE has been consistently applied by courts prosecuting mass crimes. It allows holding someone responsible if he intends the commission of the crimes and contributes to their commission, even if he never himself got his hands dirty.
Given the allegations of the defense concerning the role, and even if the crimes are not contested, you should consider completely reflect these crimes as well as the responsibility of the accused. Why must we spend so much time over the facts if they are admitted? This court was even urged not to waste time on the facts because they are admitted. And indeed, the answer is simple. In this system of law, the accused cannot plead guilty. But even the facts admitted, the facts have to be judged. And indeed, you should take into account among these facts the collaboration of the accused during the investigation. As officer of the court, we must acknowledge this cooperation. From the beginning, the accused waived his right to silence and gave 24 statements to the co-investigating judges. And he gave numerous written documents and explanations on such documents. The cooperation of the accused clearly facilitated the corroboration of evidence already in the file and the discovery or clarification of certain other elements of proof, which undoubtedly facilitated this process. Notably, he assisted in the understanding of the DK's policies. He facilitated the authentication of certain documents and handwritten elements. He participated in the reconstructions and reconfrontations, answered some of the questions from the civil parties, and gave his interpretation on certain documents and on Khmer Rouge vocabulary. So, although we submit that this cooperation was limited in terms of acknowledging his true authority and responsibility in the crimes, his testimony has, in fact, fostered the finding of the truth. The accused alleges that his cooperation is rooted in a sense of contrition. He acknowledges the immorality of his past actions and indeed has asked forgiveness from his victims, either directly during the reconstructions and through his lawyer. I have no doubt that he will do so again before you at the first opportunity. But how genuine is that contrition? Contrary to the opinion of expert psychiatrists brought forth by the co-investigating judges, I would submit that this is indeed the right question to ask. Never ask for forgiveness of his victims while supervising their torture and death. Can we believe those pleas now? If the accused is to benefit from the apparent remorse during the determination of the sentence as an attenuating circumstance, it is necessary that this remorse is sufficiently well grounded. As often is the case, the past can help us shed light on the present. To judge how far the accused has come, you must look at where he started. And for that, you begin in 1964, when the accused joined the CPK. He was recruited into the party by his teacher and mentor, Che Kim Hoor. 15 years later, the accused would supervise the torture and execution of Che at S21. That single fact, I submit, is highly revealing. From the time he heeded the call of the party and went underground in 1966 to about 1992, when he distanced himself from the Khmer Rouge, there is nothing in evidence to convincingly support any other conclusion than that the accused was fully committed during those 28 years to the cause of the Khmer Rouge and the success of its policies. The CPK recognized early this commitment, and the accused quickly became the leading security cadre of Sector 15 of the Special Zone. From there, he established and operated the Special Zone Security Center known as M13, which operated along the same criminal lines as S21 from October 71 to April 1975. Of course, the accused does not have to answer to these crimes committed at M13, not because these are all located beyond the temporal competence of this court, but rather because the crimes that were committed there were not the object of an investigation. However, you, Your Honors, must confirm M13 remains pertinent to this case. Under the direction of Sunset, another mentor that he smashed later at S21, the accused developed and refined his talents as prison leader and as torturer at M13. The accused would lead and manage all of the aspects of M13, including the detention of prisoners under inhumane conditions, their torture, and their execution. The witnesses will attest that the so-called enemies coming from everywhere within the special zone were brought to M13. The prisoners were shackled together and detained in big pits under armed guard and did not receive enough water and food. The prisoners were systematically tortured either by the accused himself, either by his subordinates. They were beaten with bamboo sticks, burnt with rags that had been dipped in kerosene, and their nails pulled out with pliers. The former guards of M13 will testify that the prisoners were finally killed in various ways, either by being beaten behind the back of their head, either by being shot down, and that the accused himself has executed prisoners. The last victims killed at M13 were killed so at the end of April 1975, after the fall of Phnom Penh. The accused was called upon to take on his new position. Witness KW33 will attest that several hundreds of prisoners were detained at any moment at M13, and during that period, the accused would command several millions of prisoners who were detained and executed. M13 was the training ground of the accused. It is there that the accused created the guard teams, executioners, a model of command mirrored at S21. It is also there, the accused established his methodological system of written records of prisoner entries and exits, and that he consecrated his reporting system that he presented to his superiors to then receive their instructions. Upon his own conviction, it is at M13 that the accused developed the interrogation techniques that were to be used later at S21. His work at M13 gave him the opportunity to train interrogators and other subordinates who will later end up under his command. Choices that followed by a devoted revolutionary and who supported the CPK and participated actively in the implementation of its criminal policies. What happened after the fall of Democratic Kampuchea in 1979 also says a lot. The accused pretends that he became at that time profoundly saddened vis-à-vis what had happened at S21 and vis-à-vis the policies of the CPK. However, we have to note that when the regime fell, he did not escape. He did not grab the opportunity offered by the chaos of the aftermath of the war to break ties with the Khmer Rouge and to acknowledge his actions as well as to make them known. On the contrary, he fled once again in the jungles with what was remaining of the Khmer Rouge troops. There he stayed voluntarily, a member of the CPK, for 13 further years. The Khmer leaders had so much trust in him that during that period, that they even sent him to teach Khmer in China for 2 years, and that they entrusted him with various official functions. It is only in 1992 or 1993 that the accused started finally abandoning the party and apparently to stop supporting its policies. Your Honors, We cannot deny that even the most ardent cadres have lived in a quasi-constant fear for their own lives under the Khmer Rouge regime. However, law, except in very particular cases, does not admit as a defense to say that they have committed such crimes by the simple fear of being yourself a victim. This would be too easy. It can be taken into account. This can be taken into account if it is proven during the establishment of the sentence, and as the evidence will demonstrate it in this case, that the accused deliberately chose a pathway that brought him to the commission of the crimes of which he is being accused, and that he participated in these voluntarily and perfectly consciously. Rather than a victim of fear, he was the one who created fear, which haunted the last days of his victims. Therefore, if we have to, at the end of this trial, establish the truth on what happened at S21, well, then I will submit respectfully that you should confront the accused to the facts in question and to the simple, single, logical conclusion that we can draw from here, rather than the image of somebody who was just executing, acting against his own volition, that he tried to show us during the investigation, practically unconscious, practically unaware of the horrors that were being perpetrated by his subordinates while he was just busy at his office. He was in reality, he was the one who put into place in a devoted and merciless way the persecution by the CPK of the Cambodian people at S21. If he admits, then and only then can he truly claim to have admitted his crimes and to benefit from that admission. To conclude, Your Honors, very soon we will begin to hear the evidence against the accused, the evidence which we just briefly summarized for you today. We touched upon a great many of subjects and did so in a general fashion. We discussed the rise of the CPK, the widespread and systematic attack on Cambodia and its population, and the armed conflict with Vietnam. We talked about the horrendous crimes committed at S21 and the factual and legal responsibility of the accused. All of these issues are fundamental elements of this trial and deserve to be examined thoroughly and also serenely, and I'm confident that you will do so. However, I respectfully submit that for justice to be done, the truth must be established. And this truth can only be revealed through the personal stories of each one of the victims of the accused. People who are hiding behind statistics, behind slogans, behind categorizations. These people had names, families, memories, hopes. They all deserve to be heard, to have their day in court, and to have their stories told and remembered. And maybe when this trial will tell their stories, their torment, and their deaths, maybe the accused, if indeed he no longer is the same man today, will finally be troubled by the suffering that meant nothing to him even yesterday. Yet despite the pain, Kaing Guek Eav, aka Duch, will have to listen to these stories because justice for the victim so requires. Well before considering the defense approach, which consists in trying to comprehend the psychological evolution that brings a human being to abandon his humanity and just to become an executioner, you should first acknowledge the humanity of his victims. And how do you render justice to their memory? You will achieve this by doing what this tribunal has asked of you, applying the law to the facts, nothing more, nothing less. Providing a fair judgment. You know the law, it is before you, the facts. are the victims. Their stories offer you the privilege to give back to us a bit of the humanity that we all lose in the face of such horrors. By relating their stories with the dignity that was denied to them in their last moments, you will also return to them their voices muted for so long by impunity, and will finally address their aspirations for justice that has been denied for so long. But this being done, you will also answer. Sorry, the interpreter says that there is.
The co-prosecutor, may I ask whether you have whether you need longer than 12 a.m. to finish your statement, or are you already there?
J'ai besoin de 15 secondes, Monsieur le Président.
I just need a few minutes, 15 seconds. By examining the stories of the victims, in so doing, you will also positively answer the question asked by Professor Yosef Arushalmi, who, when speaking about the Shoah, was asking himself if forgetting is not memory but justice. The whole respectfully submitted. Interpreter apologizes.
The President. Now it's time to break for lunch, so the chamber would like to adjourn the meeting until 1:30 p.m. And we would like to inform all participants and parties to come back before 11:30 before we can resume our session. I would like to ask the detention facility official to take the accused back to the detention facility and bring him back before 1:30. Thank you.